Good morning, everyone, and welcome. Wow, there's not that many people here. Welcome. Today is July 21st, 2015, and this is a regular meeting of the members of the New York State Liquor Authority. And attendance is Chairman Bradley, Commissioner Kim, Associate General Counsel Amaretto, CEO O'Brien, everybody has new titles, and myself, Secretary Held. The next meeting dates have been changed. All right, they are set for Tuesday, August 18th and Wednesday, August 19th. There'll be two separate calendars. However, they will be back-to-back meetings. These will be the only meetings that are being held in August. The first meeting date set for September will be the 1st. We'll make sure that our website is updated to reflect this date and this change. All meetings are held in our New York City office with video conferencing available at our other office locations. When your matter has been called, please approach the podium and state your name clearly for the record. We will go to Buffalo first, then Albany, then here in New York City. Members, do you have any announcements to make? No announcements? Okay, then we ask that you please silence your cell phones. The first item today in Buffalo is 1681 S&W Club Corporation.
Chairman, Commissioner, there's no one present or signed in to represent S&W Corp, but I do have opposition present.
Okay, thank you, Michelle.
We'll hear from the opposition.
Please step up to the podium and state your name.
My name is Dan Deutsch. I own a building at 153 Liberty Pole Way in Rochester. I also am a license holder at Abilene Bar and Lounge.
Okay. And what's your main basis for your opposition?
Well, I guess this somewhat feels like deja vu in that I spoke in this room probably 3 months ago at a 500-foot rule. And we are very concerned in our neighborhood that the building and the facility that was Club Envy / Club Pure for 7 or 8 years will return to form. For many years, our neighborhood was unsafe. Our neighbors and residents were fearful every Thursday, Friday evening. And in the 2 years that this operation has been closed, it has been calm and peaceful and serene, and people of all ages walk our streets without fear. So we're very, very concerned if it was to reopen. Our feeling is also that after being at this 500-foot ruling, that the applicant, who was the head bartender at this location, is really associated with the same group of people. She spoke of being the head bartender there for a number of years, for just about its entire lifespan, yet she expressed ignorance, really, of any of the goings-on that were of such magnitude. This place, the Club Envy, suffered multiple infractions. There were stabbings, there were shootings, there were violence on a continual basis. The prior owners or operators provided security, yet that security seemed ill. And the security that was employed looked like an occupying force in our neighborhood, wearing flak jackets, pistols on their waists, pepper spray, billy clubs, and yet they were unable to control the amount of violence. When asked what was going to be different, I don't think that the applicant expressed any valid plan whatsoever as to how they were going to go about addressing any of these problems, who they were going to go after as far as an audience, or what the plan was. She spoke of maybe doing a sports bar theme at happy hour, maybe doing some food, and yet when the deputy commissioner asked her about the menu or the kitchen facilities. She acknowledged that there is no kitchen. They'd have to make some money first, and then maybe they'd have a kitchen. Maybe at night it would be a dance club. I think we heard a lot of maybes, but nothing that gave the neighborhood any solace or security.
So we have a report here, the 500-foot hearing, so we're aware of all that testimony. If you have anything else to add, feel free, but we have
Yes,
all.
I do. There were 3 letters of support that day. There was a letter of support from the property manager, somewhat self-serving in that he would rent to these people. There was a letter of support from Councilman Adam McFadden in Rochester, saying that it would be good for the community. I'd like to note that Councilman McFadden does not represent our neighborhood or our district. He's not even an at-large councilman. Our councilperson is Elaine Spall, and she did not offer a letter of support. I think the city's position, aside from Adam McFadden, is pretty clear, and they're not thrilled about this happening. Also, one other point, they talked about parking and how it wouldn't be affected and that there's more than enough parking. They were talking about using the parking lot from the Harrow East Ballroom, and they stated that parking lot is rarely used after dinner hour. I checked in that from March going forward, for 36 of the 42 weekend nights, that parking lot was filled till 11 o'clock at night with events, from weddings to bar mitzvahs to parties to social functions. That parking lot is used. The third letter of support was from Ted Rund, who has the lease on the Harrow East Ballroom. He has since called our neighborhood association and said that he has rescinded his feeling of support for this project. He called me about 2 weeks ago and asked for.
We also have a letter from him rescinding the support. So if you don't have anything else to add, we can move on.
Great, thank you very much. I appreciate your time.
Sure, I'm ready to vote.
Did anyone else come in the room or no?
Yes, there's other opposition present.
My name is Margaret Thomas. I live at 147 Liberty Pole Way. My building is next door to the building that we're talking about. I've been there for over 25 years. I was the owner of a Harrow East building, which is across the street. I live there, and I am disturbed by the swearing, the violence that's been there at during the time that we're talking about. And my friends, my associates have come, in fact, they're afraid to come to visit me because of the behavior that in the neighborhood. I object to the use of that building being used for similar to what it's already applied for. Thank you. I mirror the information that Ms. Daly has also given you. I'm not going to repeat that.
Thank you.
Step up to the podium.
Good morning. My name is Sarah Valencia, and I am a municipal attorney for the City of Rochester. Position to the application of S&W Corp. For a liquor license for 117 Liberty Pole Way. I had previously had a written submission that I mailed in for the 500-foot hearing that attached several police reports which documented some of the violent criminal activity at 117 Liberty Pole Way. I would ask.
We have your submission.
All right, thank you. In addition to that, I would just add that the city is concerned that the prior operator of this establishment, Sean Ducarry, really is the principal behind this current application. Following the 500-foot hearing, Mr. Carey has come to City Hall, in particular to the mayor's office, several times, aggressively seeking a letter of support for this application. And of course, his request was denied by our mayor. In addition, I also had the opportunity to meet with Ms. Walzak, who I believe is the applicant behind this current application, and I would echo the sentiments given by the gentleman who testified this morning as to the lack of specificity she was able to provide with regard to her business plans. That coupled with the aggressive advocacy of Mr. Carey, his representation that he is her consultant of sorts, leads me to believe that he really is the person who is the driving force behind this application. It's my understanding that he has a prior negative history with his prior liquor license for the same establishment. So it's our belief that if this application is allowed to go forward, it really would just be another mechanism for the same person, that being Mr. Carey, to continue with the same operations that were so problematic and troublesome, and as a matter of fact, detrimental to the quality of life for the residents and other businesses in the Liberty Pole Way area. So if there are no other questions, that's all I have to say.
Thank you.
Thank you.
Thank you.
I'm ready. Chairman, if you're ready, I'm ready to vote.
I'm ready.
This is a 500-foot case, and City of Rochester is opposed to it and details all the reasons why it's against this license being granted. And I agree with everything that the opposition has said today, and therefore I vote to deny.
I also vote to deny based on the prior history at the location, the prior history of the individuals involved in the license. So the license is denied.
Is there anyone else in Buffalo?
There's no one else in Buffalo.
Thank you, Michelle. In Albany, 1717Q, TSB Bar.
Oh, yeah. Good morning, members. Glenn Tabista with TXB Bar. With me is Tony Brighton, the principal of the applicant. Ms. Brighton was also a principal of the prior license that was at this location. There were serious partnership issues at the prior location. Out of fear for her safety, she became absentee at the operation of the business. She has taken the corrective steps for the new application, first of all, by removing the problem partner, and secondly, by being hands-on at the location at all times, in addition to hiring a full-time manager to work with her.
So what's really changed, except for the removal of Mr. Gould, her previous partner? They were licensed in December 2013, and then the license was canceled in October 2014, within a year, because of the adverse history, sales to minors, and also Ms. Brighton at the time was the head bartender, correct?
Were you? No, she says.
Yeah, I was in charge of them, but I wasn't the head bartender. No.
So you were in charge of what, the premises, or you were in charge of the bar area?
She was a principal at the location, but because of the partnership problems, her authority was overridden, and she was basically out of fear for her safety, removed from the premises.
So she was never at the premises during this time period?
Rarely.
Can you explain fear for her safety?
Yeah, don't get that.
Were there police reports?
She had called the police on numerous times, and she was told because they did not observe anything, it was a civil issue.
I don't know. Well, there's strong opposition from the chief of police. He's in support?
I believe there's a letter of support.
I'm sorry, he's in support, I'm sorry. I had
Thank you.
my notes backwards here.
Thank you.
This is the one in Goshen, right?
Yes.
Yeah, that's the police chief from the town of Goshen? What about the city of Middletown police chief?
There's no letter, but the chief police of the town of Goshen.
Who's the letter from?
The chief police of the town of Goshen.
The town of Goshen is the one that wrote the letter.
But he has no jurisdiction in Middletown.
That's correct.
So why would we be getting a letter of support from another town?
just to attest to his knowledge of her as a police chief.
Well. Yeah, I mean, you had a shot at a license here only a couple of years ago, and the adverse history within a year is, you know, it's very poor. And I just can't see how anything would change with now you operating this by yourself. We don't really have the details about what you meant by fear of your own safety. So I vote to deny. I don't see anything different that's coming out of this.
I vote to deny as well, mostly because of the past history at the location. You know, I understand there obviously was a problem with your partner, but you were involved in the location. So I vote to deny as well.
Thank you.
Thank you.
Is there anyone else in Albany?
No, we're all set, thank you.
Thanks, Rose. 1684, JCN Chung International Corp.
Morning to the commission. Frank Nalaveco, representative for the applicant. So we're here for a reconsideration, and it looks like there was some confusion with the town. Back in March, first of all, I filed the application for an RW.
I don't have to go into it. I mean, I'll grant the reconsideration condition upon satisfaction of the variance approval.
Counsel's office is going to request that we send it back for further investigations with the town. With respect to the confusion, we want to get some clarification on that.
Okay.
Okay, but I vote for the reconsideration as well.
Great. Thanks.
Good luck.
Excuse me. What's his name?
Excuse me?
I'm sorry, the fee was refunded though, so we will need to get the fee back before we can reactivate the application.
Okay, so you're going to do the investigation.
Well, reconsideration was granted, so we can do it as a part of the application review process. So I'll
Okay.
need the fee though to reactivate it.
Okay.
Okay?
Is there any other information you might need? Letters, nothing? You have everything? Okay.
Not that I'm
Great.
aware of. We'll let you know.
Okay.
1678, J&R Symposium.
Good morning.
Good morning. Stacy Weiss, representing the applicant J&R Symposium LLC. It's a new liquor store that will be...
Well, I'm sorry to interrupt you. Can we just hear from the opposition first, I guess?
Absolutely.
Thanks.
Sure.
And there's a 200-foot issue here. Do we address that?
Hi, good morning. Glenn Wright. I represent A&S Liquors, Inc. It's the closest liquor store, 895 feet away. I also represent E&D Liquor Store, which is the fifth closest store. Also here present is A&D Liquor Store, where that is the second closest store. And I have a letter from Wino Tea Liquors, which is the fourth closest store, that I'd like to hand up at this point. It's letters of opposition I just received. I've also received letters in opposition from both the nearby churches and an article regarding a liquor store robbery earlier this year in the immediate vicinity. I'd like to hand all that up. I have several copies of each.
Sure. Thank you. Or is it, or how did,
Yeah.
one of each kind of a thing?
Yeah, I made like 4 or 5 copies of each.
Hope you read
It
fast.
just came at the last minute, sorry. Okay, so I submitted a memorandum last week in this neighborhood, in both the zip code where the store wants to open, 11225, and the immediate next zip code, 11226, the area of Crown Heights in Brooklyn. There is a decreasing population, unlike many areas in Brooklyn are gentrifying. This population, according to the most recent census figures, 2009 through 2013, and then also Community Board, there has been like about a 7% decrease overall in the population. The poverty level in the area has stayed pretty much stable from 2000 census through 2009 through 2013 census.
Well, let me ask you this. Did you read Ms. Weiss's submission?
No, I did not.
She indicates in her submission, using significant newspaper articles as well as articles off of the internet, that there's a significant amount of development in the area.
Well, I'm going by census figures and population.
I actually read your figures, and they're estimates.
They're estimates from 2009, but the 2010, I used the estimates from 2009 to 2013 because they're a little more recent. Even 2010 may be somewhat outdated.
Did you look into whether there was actual residential development in the area?
Yes, I did. I did not see much residential development. I did address in my memorandum the demographics, that this is only 4 avenues from Prospect Park, and that this is mostly mixed-use buildings. It's mostly brownstones. It's not like Bushwick, where there is vacant lots and industrial areas that are either being torn down or repurposed for residential. I mean, I have been out to this location about 3 times in the last couple of weeks. There is no high-rises. In most of these areas, you will see high-rises here and there and a lot of gentrification. There is none around here. And I think the fact that the poverty level has stayed stable and the crime rate is actually increasing. I attach statistics from the local precinct that the rate of robberies is increasing. This is completely counterintuitive. If this area was being gentrified in development, there would be more community policing, there would be a lower crime rate. Neither the poverty level and the crime rate speak to an area that is not becoming gentrified. And just given the stock of housings all along Eastern Parkway there, where it's old brownstones or old apartment buildings, there's no room. It's a highly residential area. It's like some of the areas of Flatbush along Prospect Park where it's already built. There's no space to just tear things down and build new buildings. So in this street also where they want to open Rogers Avenue, it is off Eastern Parkway. It's sort of a side street. It's not, busy foot traffic. The area is surrounded by church. The street. Ms. Weiss submitted a letter that they don't use the rear entrance, which directly across the street from this liquor store. I've spoken to the Board of Trustees that wrote that letter. I don't know what representations were made to him, but he had no idea what he was doing when he was facilitating the opening of this liquor store. He's a little perturbed about it.
We also spoke to the pastor.
Yeah.
We have a letter that the rear doors are only used for exits, primarily as exits on Sundays. But he didn't give a position at that point. We now have the letter that he's in opposition.
Yeah,
but
no,
that's not a 200-foot law case is all I wanted to say.
I believe that. I'm not contesting he would have misrepresented whether or not that door was used as an exit. I'm not saying that at all. I received that as part of my FOIL request. Right. It's just he didn't know the impact of what he was writing, and he's now writing a letter that he's vehemently opposing it, and he's embarrassed that he facilitated the opening of this liquor store. I've also submitted a letter from another church in the other direction, directly on the Knicks block, that is opposing it. As I said, I submitted a letter from another liquor store that's opposing it.
How many of you, the people that are opposing it have bulletproof liquor stores?
3. And 1 does not. The Wino Tea, the one that I submitted the letter, is not a bulletproof. The other 3 are. And I'd like to address, I've been out there, even the delis out there are bulletproof. I handed up a letter from a liquor store robbery immediately near there. When I spoke to my client in his own liquor store, people were loitering. They were coming in and out. I just don't think this area can support a non-bulletproof liquor store. And Wino Tea has submitted a letter talking about their gross sales. They are not bulletproof. To address the sales, 3 of the nearest 4 have decreasing sales. I put that in my memorandum. And I believe the 5th, E&D.
Well, it looks like 3 out of the 4 have decreasing sales because the one other store seems to be dramatically increasing in sales.
So then they have faced increased competition in the area, and they've been impacted by that. But 3 out of the 4 do have decreasing sales. As I stated, my client A&S is only 895 feet away. It's directly 1 avenue over, 1 block and 1 avenue over. It would have a major impact. But they are on Nostrand Avenue, which is more well-traveled. The street where they want to open, it consists of a large block-size armory, high schools, churches, small storefronts. There was another liquor store that came up on Rogers Avenue last year. This is not one of the easier stores that's going to attract a lot of bulletproof. This is a primarily residential area. I would submit that this store They have a basement, which they don't see, I'm not sure is going to be used for storage. I'm not sure how much of this floor plan is going to be actually retail area, but the nearest 4 liquor stores that exist now have 3,100 square feet of retail area. I noticed that they don't list the basement on the application, yet the floor plan shows stairs going to a basement, exterior stairs, and I assume there may be a warehouse permit, and you're going to be adding a significant amount of retail space to an already saturated area. You know, 4 stores within 1,500 feet and 7 stores within 2,400 feet is fairly saturated. And, you know, I know that people are coming in and saying they're going to be bulletproof, but, you know, clearly that all these stores, the 7 within 2,400 feet, if they felt that the market could sustain a non-bulletproof store and they could be safe and they could operate their business, I would submit that they would do that, and they should have that opportunity even to do that and file a method of operation and do that. You know, it just doesn't make sense that we need another store crowding this area because they have this, you know, brilliant idea of being open floor plan. That opportunity is not lost on my clients, and certainly if the area does, in fact, in the future become gentrified, I'm sure they'll avail themselves of that idea and become open floor plan.
Hello.
Hi.
Hi.
Okay. First of all, I know I handed in a considerable amount of documentation regarding the gentrification of the area, as well as the number of buildings and apartments that are being built in the area. There are approximately 20 new residential buildings that are being put up in the general vicinity of Crown Heights. And in fact, there are at least 3 buildings that are being put up with, I believe, about 400 apartments right within a block or 2 of the store. Rogers Avenue is actually a very busy street. Traffic is extremely heavy going up that street, and it is a very busy thoroughfare. It actually bisects Eastern Parkway. So it is a very, very busy area. As far as the church is concerned, I just want to segue into the church. I spoke to the church several times. I spoke to the woman at the church and informed her exactly what was being done at that location. I told her it was a liquor store. I explained to her at length what was being done. In no way was anything misrepresented to her about what was being done at that location. She understood perfectly that it was going to be a liquor store there. And she had no problem with it, and she put in the letter that it was, that she told me that it was only used as an exit. And we even discussed how the letter should be written. So there was no misrepresentation as far as that door was concerned, or what I told her about it. And I believe they spoke to her also. So that I wanted to clarify that issue. As far as gentrification, population, I believe you have in the documents there that Brooklyn itself has grown so much that it is one of the largest.
Right, but I don't think we need to focus on Brooklyn.
Well, I mean,
Let's just
that
talk about
area-
this
okay.
immediate area.
I also want to show that it's also mentioned about the how close they are to Prospect Park, and I want to show something about that also. I have a map here that's they're not that close to Prospect Park. Just hold for a second. Can you hold one in? This is where the applicant is, right here. And the applicant is right here. Now,
Ma'am, we have that map in your submission. I've looked at it at length.
Okay, I just wanted to make sure that, oh, and also, but I also want to make it clear that the five closest stores, this whole area here is not being serviced at all. So I just want to show, they're saying that it's oversaturated. There's nobody over here. So they can clearly cover this area over here where there's no stores. So I just wanted to show that there's no oversaturation there.
Oh, are we certain there are no stores there, or is it just not the 4 closest or 5 closest stores? It's hard to tell. And from Prospect Park, it looks like from your other map submitted, it's 1, 2, 3, 4 or 5 blocks away?
Yeah, it's not near. And then here, this is the construction.
Right, that's what I'm looking at, and I'm counting 4 or 5 blocks to the park.
Yeah, it's not close. This is the construction that's in the general area. So I don't know how, possible that there's no construction going on. These are all residential buildings going up with the units next to it. Also, the 5 closest stores, how they're doing. When you look at that last number is only for the first 5 months of the year. Okay, so maybe they went down from 2011 to 2012, but for the last year, 2015, that's for the first 5 months. You have to at least double that, if not more than double it, because the money's made from June to December. That's when the holidays are. Okay, so when you look at that number, it's more than double that number. Okay, so they're all going to go up substantially in 2015.
Well, no, not if that's your argument for the second closest store. They're at 120,000. So if you double, it's 240.
That store I can't understand. Okay, I even put in my
Well, and then the
memo,
fourth one,
I can't
it'll be
understand
the
that
same.
store.
The fourth one will be flat, and the fifth one will be down. So the only 2 that are going up are the first
Well, no,
and the
if you
third.
look at the last, no.
First, actually, only the first, because the
No,
third
that's-
is also.
No, multiply it by, no,
I am multiplying up by 2. Which one are you looking at? Number 5?
no, look at, wait, no, I'm sorry. Look
Name
at
this. Name this store, and you can multiply by 2.
the last number.
Right. So King's Eastern Franklin Liquors
The year
Ltd.
before.
2015 was $120,000.
That store
I'm
can't,
just saying, if you double, it's 240. In 2014, it was 516. Let's look at the fourth one. 462 was 2014. At 2015, it's 233. You double that, it's 466. So it's flat.
and the year before, they made what?
465. So it's flat. Okay? Are we getting this? And then the last
That's
one.
only 5 months. That's only 5
No,
months.
and then the last one, we have 379 for 2014, and 2015 had 162. You double 162, you'll have something like 324, which is down significantly. So
Wait.
let's move on to the next argument about that, because I don't think you're going to tell me that the sales here are increasing by any means, except for the third. Even the third store that you pointed out is 1.2 million in 2014.
Yes.
We double 464, which is what they submitted. That's only 928. 928. So they're significantly down from 2014.
It's at least.
You asked me to double the number.
No, but I'm
I
saying
doubled the number.
No, but I'm saying it's 5 months. That's 5 months, and 5 months of the lowest time. From you have to remember, from January to May is the least amount of money liquor stores make. They make their money in the summer, Christmas, Thanksgiving, for all the holidays. That's when they make their most money. So this is the lowest time of the year, the first 5 months.
Right there.
Yeah, there's something wrong with that one.
Yeah. That means to the date that this was submitted to
when did they
me.
submit?
So I would say I submitted it for the July 21st, so it was June.
June. So 6 months. It's half a year.
Yeah.
Okay. All right, next argument.
Okay. Okay, based upon the incoming amounts of units, buildings, people that are going to be coming in the next few years, it's going to be a significant number of new people. The area that they're going into is tremendous growth. They're going to be an open store, which I think is very significant. There's only one other open store within the area. They have, to be accused, according to the memo that was submitted, of going into the place, being an open store, and then once they get there, submitting a alteration to become a closed store, I think is not very nice. I don't appreciate that. Also to insinuate, of course, there is a basement, but right now they're not using the basement because it's an exterior entrance and they can't use it right now. If they do get approved for a license, they will most likely put in for a warehouse permit, but right now there is, they cannot use it because they only have an exterior entrance to the basement. They also would like to try something a little different in the area, and they want to concentrate on a higher-end premium bourbons and about that, what he wants to specialize in, but that's something that's not available in the other stores. So he wants to do something a little different.
Can we hear from your client on that?
Oh, absolutely, yes.
Right now?
Absolutely.
Have you been to all the other stores personally?
My name is Ryan Granville. Yes, I have.
You have, okay. So what are you going to offer that they don't have?
I'm going to be offering premium and super premiums, whiskeys, and bourbons.
Such as?
In the realm of, I would say, all the reserve collections for brands such as Johnny Walker Blue, Johnny Walker Gold Reserve.
I mean, Johnny Walker Blue, I think. Okay, keep going. Sorry.
Jameson Irish Whiskey, 10-year plus and older, limited reserve. Kentucky single barrel, so it's mostly single malt beverages. Whites are Canadian whiskeys, Japanese whiskeys. So pretty much it's going to be all the archives, the reserve collections, the platinums and the XOs. So those are the ones that I'm going to be offering.
And you saw that the other stores didn't carry these items?
Majority of the stores had one or two, but they didn't carry a significant amount of these particular products.
Okay. Do you want to just respond to the product mix? Just quickly, just based on what he listed off.
What he listed off, I have almost everything that he said.
What don't you have?
And plus more. He said the XO or the reserve.
Speak to us, please.
The reserve in which brands, because there's multiple different brands. I have like, let's just say, 10 different reserves. And on next month, I'm reserving Poppy Van Winkle, which I don't think they know which month to buy it in at. We have been in business for almost 9 to 10 years. We know.
Okay, I just want to know about the product mix. Thank you. Do you have
And
something?
what's your store?
A&S, the closest one.
I think he also wanted to briefly address the development in the area. He's more familiar with the neighborhood.
Yes.
You want to
I'm here for almost 9 to 10 years, and most of the buildings are going up near his store, not near them. Back at his store is mostly like daycare, churches. There's like two churches that's really close. Like one, there's a church right across the street, an armory. And there's very few buildings going up near him. Everyone is going up near E&D Liquors.
E&D?
Yeah. That is the farthest one. One of the farthest ones.
Yeah, that's what it seems from the map.
Yeah, that's what that's how she referenced it.
Right.
Yeah, that is closer to him, not them.
Yeah, most of it is on next to the park.
Now they're acknowledging that buildings are going up.
Yeah.
Well, there's no buildings will go up. Now.
All right. Anyway, thank you. You can, Ms. Weiss? To what?
I didn't mean to imply Ms. Weiss made a misrepresentation. I spoke to Mr. Lewis, who wrote these letters. He wasn't aware what he was signing. His secretary gave him something to sign.
That's fine. The
He didn't
church
understand.
issue is.
Okay, yeah, and my memorandum clearly addresses, year by year, gross sales going over several years. I didn't even
Right, so
consider
we see
extrapolating this
that.
year.
We see that.
And, and as far as these new buildings, I mean, I'm talking about a population loss of almost 8% in the two adjoining zip codes. I mean, even if they put up 30 new buildings, you still have a net loss in population.
Okay, thank you. Ms. Weiss, you can finish your presentation.
I was just, I just think that the area calls for an open store because the area has and is undergoing such a tremendous change. If you look at the New York Times article, it talks about how Crown Heights has undergone a big change since the Crown Heights, since the riots back in the remember that, the 80s, and it's now becoming a much more friendlier area. Coming into the area, moving into the area, want a place where they can go into a store and actually pick up a bottle of whatever and look at it and touch it and feel it and decide what they want to buy. And they're going to have tastings, and you know, people want to do that, and they want to introduce people to new flavors. And I think that that's what this neighborhood calls for, is an open store. And I think that they'll do a good job there.
Okay, thank you. I mean, I'm really,
My client just wanted to point out that his store, the nearest store, also has wine tastings.
Okay,
okay.
thank you.
All right, thank you.
I wanted to raise one other thing. I noticed there's two gentlemen up here. They own several businesses in a home together. The name of the business is J&R. That would be James Lewis and Ryan Granville. I assume the authority has investigated whether or not there is any undisclosed interest here.
One is the manager and one is the owner.
They've both filled out questionnaires, right? So, or has James? Do we only have it from Ryan?
Ryan is the owner, and James is going to assist him with
Only
managing.
we didn't get a personal.
We didn't get a
questionnaire.
questionnaire
We
from.
don't ask as a general rule, only if there's a reason for us to want
I
it.
see.
I mean, if you want to.
Do either of you have experience owning a liquor store before?
No, but I did intern.
Can you come
Oh,
to
yes,
the?
I have a letter here about, yes, I do have a letter,
I
yes.
did intern about in 2013 in a liquor and wine store.
Yes, I have a
Just to
letter.
get the idea of how
Sure.
it runs, basically.
How long was that?
1 year, 2013, 2014.
Stacy, if this gets approved, you should submit an updated method of operation to reflect the manager.
Oh,
Because you
sure,
said
no,
no
yeah,
on
that's no
there.
problem. Absolutely no
Tough
problem.
one for me. It is. That's why I was trying to get more information.
That's no problem, we could submit
I
a,
mean, part of it is that it's true there has been a lot of development in this area, but most of it has been closer to the
oh,
park.
and I have one more thing to add. There hasn't been a new liquor store, an actually new liquor store, since 2011. There have been transfers of liquor stores. In 1995, there were 2 liquor stores. 2002, there was a liquor store. 2009, there was a liquor store. But there hasn't been a new liquor store issued since 2011. So it's been 4 years since a new
Right.
one came into the neighborhood.
So, I mean, if this were approved, that would definitely be on the license. I would have to stay an open store.
Oh, absolutely, it would be an open store.
I'm talking to the chairman
I'm
right
sorry,
now.
I thought you were talking, oh, I thought.
We're discussing at this point.
I'm sorry.
So to me, you know, the location itself, the exact location, it seems pretty well served by the other surrounding 4 stores. There's a lot of development closer to the park. The fact that it's an open store is an argument for the approval. The product mix, I don't think there's anything new or different that's going to weigh in their favor on that front. The sales have been fairly flat or declining, except for the one store that seems to be the open store too, that came in and started taking some of the business away, which is also an argument in favor of approving an open store. So that's kind of where I am.
I'm ready whenever you
You
are.
ready?
I don't disagree with any of that.
Yeah. So, you know, given that there hasn't been a license issued here, a new license in however many years, and given the new developments that are occurring, I will vote to approve, but on the condition that it remains an open store at all times. If you decide that you cannot maintain an open store, then the license will no longer, license will be canceled at that point. It'll be a condition to the license.
Understood.
I also am going to vote to approve, only because it is an open store. From the location you're at. And the other thing that I did find extremely persuasive is that it's clear that there is development going on here. And these are from independent sources. There are at least 1,200 new units of housing and I'm referencing an article in the New York Times from July of 2014 that indicates the number of housing that's going up and that the neighborhood does appear to be gentrifying. And I do believe an open store would serve that neighborhood just based on what they're saying, the population that's moving to the neighborhood, the age demographic, as well as the fact that the one store that is open clearly is taking significant sales away from the other stores in the area. So I think that given the fact that that store is so far away from your location and your location does appear to be near the development that's going on, I'll approve the license.
Thank you very much.
Good luck.
1680 VLZ Liquor Store Corp.
Morning, Robert Swednick for the
That was
applicant.
the hardest case we've had.
Yeah, it's right on the
In
border.
3.
Yeah.
As of last week, I know there was no opposition. I don't know if anything's been received since then.
No.
No? Okay, told there's no opposition. Closest liquor store is approximately 1,500 feet, about 6 blocks away. So we think that there is a need in the community for a store at this location. There's been no opposition to it. I think we've presented everything. There is a basement, which he is not, I've explained the warehouse permit. He says he is not going to use it to store liquor. He doesn't need it. So we're not going to be applying for a warehouse permit for that. I don't know if you have any other questions about the applicant for the location.
Do you have any prior experience with liquor stores? No. Can you come to the mic and just,
No, right now.
all right now? So how did you come to decide you wanted to open a liquor store?
Do you want me to explain? Only because of his English.
Oh, sure.
He works in a steel mill in Sayreville, New Jersey. He's been there for over 12 years. He makes a very, very good income. That steel mill basically is going to be closing. They're shifting everything to Canada. He is looking for basically a future. He's still a young man. That is not a skill which is easily transferable. He understands the retail business. He feels the liquor store is something that he can learn and develop and not need let's say, a significant education and be able to handle it. But he doesn't have extensive experience working in a liquor store, but it's something he's
So
interested.
how did he find this location if he lives in New Jersey? Or do you?
No, he works in New Jersey. He
Oh, he
lives
works
5
in-
minutes away. He lives
Oh.
right there. Now, this is the area he lives in. That's why he found a location. He was looking for something closer to home, because after commuting to Sayreville, where he has to be at 7 o'clock every morning, he's looking for a place close to home. But he lives in Jamaica, about 5 minutes away from where this location is.
Yeah, my main concern is if you look at the 5 closest stores within a mile away, 59, it's almost 8,500 square feet of stores, and they are all having flat or declining sales for the past couple of years.
Well, the stores are I guess, 3 of them are all on Hillside Avenue, which is not even the same traffic, because he's on Jamaica Avenue. So I don't think they're going to be drawing the same people at all, because most of them are going to be getting the people on Jamaica Avenue. He's looking at, I'll call it south in Hollis, which would be all the residential houses behind his store. So I don't think they're really going to be competing in the same market even.
But there are 2 on Jamaica Avenue, and they both have declining sales, and they're
There's
much
only
larger.
one that I know of, which is AAA.
Right.
And we didn't get any records on that sent to us from the authority, so I don't know what those sales reported were. And that, again, is more than 6 blocks away.
Well, for the past 5 years, they've been 211, 214, 136, 206, and then they're at 100. I mean, with those kind of sales, I just don't know. 750 square feet additional space on the same avenue, about 5-6 blocks away.
And obviously, they're not opposing it.
All right, I'll vote to approve this license.
Thank you.
I vote to approve as well.
Thank you very much.
1717D Amber Avalon Corp.
Morning, Warren Pizetsky for the licensee. The licensee, I don't even recall how they found this was on an agenda, but they never received the charges. I checked with the Secretary's office. The certified copy was undelivered, and something about the post office, but their address is correct. There's somebody there from early in the morning to late at night, and we'd just like the opportunity to defend.
So, is the DJ still playing his music there? Music?
I really don't know. I don't really want to try the case today. I would just like the opportunity to either defend it or settle it. The charges were only brought a couple of months ago, even though the allegations go back to last summer. And I really haven't had an opportunity to go through it, you know, what the basis of a settlement might be, but just the opportunity to either defend or settle.
Your client told you that the certified mail wasn't delivered? That's the argument?
They never got the charges. We don't know what happened with the regular mail. It didn't come back to the authority, but...
well, you know it's sent by certified mail.
I understand. It was not delivered.
Okay.
And the Secretary's office verified that.
Well, I have the printout. Yeah, that one came, hang on a second,
Yeah.
that came back.
And we really don't understand why. The address is correct, and there's someone there all the
The
time.
landlords came back. The certified, we got the printout from the Postal Service. We didn't get the card back, but it
Okay.
does indicate.
And we'll either defend it or settle it quickly. That's all we're asking.
All right. I have.
So what is this technically, a reconsideration? What are we
No, it's
talking
just
about?
to reopen the default. You want to reopen the default, return to council.
Or not an imposing penalty.
I'm ready to impose a penalty, but if you want to return to council, I can do that too.
Yeah, I would
Request
return
a
to council.
Okay, let's
hearing.
return it to council.
Okay.
We can, all right, we'll return it to council.
Thank you very much.
Card, that's why I had a problem.
1683, Mr. Vino. This is a request for reconsideration of a full board disapproval.
Morning to the board. My name is Michael Riley. I represent the applicant, and thank you very much for the request for review being granted today. I see someone is here, so I believe I'll step aside. Is that correct?
Sure, thank you.
Thank you.
Well, it's technically, no. Where it's.
It's
You've already
might as well
done it,
just,
yeah.
she's here, so go ahead, please.
Hi, good morning. My name is Chunyang Zhang from
No, I'm
Chunyang
here.
Law Firm. I'm the attorney for the Vintage Wine. We are the second closest to the applicant. We're here to oppose for the new liquor store, Mr. Vino, because the first reason is very close. We are the second close, and the
All right, so we've already denied it, so we already know why you're opposing it. But what you could maybe do in this case is just wait for them to give us new information that we'll reconsider, and then you can counter that if you believe it's necessary.
Okay, thank you.
Okay, thank you.
Thank you. During the full board hearing, well, first off, I will not restate everything that I've sent in the request for the review and also the individual to the left, her firm appeared, they stated to the board the proximity, which was absolutely incorrect. The board found that they were over 1.8 miles away. They were not one of the 4 closest liquor stores. Also, the gross sales receipts that was given could not be given and could not be testified to because they just purchased the store. Nextly, a major statement which I was stating to the board at that time was the public convenience and advantage, which is what the board must consider, as you're all aware here. I stated the reasons, I stated why in Seaford, right behind, west of the shopping center where the proposed premises is, there is absolutely no liquor stores there or package stores, none whatsoever. The other ones are in different towns because Seaford is comprised in one area of Hempstead and another area of Oyster Bay. My client grew up right across the street from the very establishment. He knows the area very well. He's lived there for the last 17 years. He also sells real estate there. He knows basically everybody in the very small knit area of Seaford. I outlined what people shopping in a local community would do. I don't want to restate it, but it would add taxes. It adds value to the neighborhood. It creates employment. The list goes on and on. I've also given to the court, to the board, 5 separate articles which state and concrete our statement with regards to same. Again, public convenience and advantage is what is different on every single application. I set for the cases that actually say that it has to be an ongoing and it not be a rule of bulletin. It cannot be a predetermined policy. So I believe that this application, I believe, was incorrectly denied. I think that based upon the supplemental and the original submissions, along with the map, if I may, I've submitted to the board. Right behind, this is Hicksville Road. This is Seaford. There's not one liquor store. On the side, you have the Southern State. On the other side, you have 135. You cannot go outside of it. You have to come out through Duff Place.
So a couple of these addresses with the closest stores with Seaford addresses. Seaford, Seaford. There's one 3978 Jerusalem Avenue, Seaford, New York. Where's that?
That is in the town of Oyster Bay, correct?
Can you show me on your map?
Of course.
approximately where that is?
It's, if I may, it's this way. It's to the,
Is it over on the other side of
Yes.
Hicksville Road?
yes. It's actually on the other side. It's south of 135. Correct. Of 135, which, as you could see, the tunnel, it actually funnels everybody out into Duff Place. And my client lives here for the last 17 years, and again, the establishment is here. There is nothing whatsoever in this area that would service the community. And I'd like to have my client make a statement as well as to how he found the establishment and what training or knowledge he has with regards to his hopeful future running of a store.
Go ahead, please, go ahead.
Good morning. Thank you again for the reconsideration. Selling real estate in the area for the past 8 years, I've become very familiar with the clientele, the shopping centers in the area, the home sales. Living there for the past 17 years, it's my neighborhood. And this is my shopping center. I live right in between the 135 and the Southern State, which is the area that I am looking to open up. The residential homes that are directly behind that shopping center is where I live also. We all funnel out right into that area of Hicksville Road. To get to any of the liquor stores that are closest to me, you'd either have to cross over the Southern State Parkway or Route 135, which is the Seaford Oyster Bay Expressway. The homes that are right to the shopping center, pizza, deli, the door grooming place, Dunkin' Donuts, everything is there with the exception of grabbing a bottle of wine and going home with it. So, again, I thank you for the reconsideration, and I hope.
So can you?
Yeah, let's do this.
How many lanes is 135?
The 135 is 3 lanes. 3 lanes? Yes,
Each
it's
way?
a 3-lane highway.
3 lane each way?
Correct, yes. Mhm.
So A is our applicant and B is the.
Again, if this did get approved in this shopping center, it would be the only package store in Seaford in the town of Hempstead. There are no package stores in Seaford in the town of Hempstead. And that's the clientele that I'm looking to service.
It is still a driving neighborhood.
Yeah.
But also, I've pointed out when the board has approved something where it's directly across the street, so the proximity of the liquor stores, I don't believe, should be determinative in the board's determination today.
This one is. 3 minutes. This one,
Crosses over that big, what's that big one?
I don't know which one this one is. This one,
If this were a walking town, I could see that those two bigger roads would affect public convenience and advantage. But when we look at the two closest stores driving distance, it's really, one's a straight shot down about, you do have to cross over one of the bigger roads, but it's a 3-4 minute drive one way and 3-4 minutes the other way. So,
I understand what you're saying, and I apologize for.
and I think that's what we based it on. And in addition to all, in the past 3 years, we had issued there was one that was already there. So 1, 2, 3 new licenses within 2.4 miles from there.
Which is, although it's Long Island, it's still Nassau, and it's much more congested. It's not Suffolk, and it's not the East End. Additionally, the board approved one directly across the street, just a town away. Now, is that too many liquor stores there? I'm just asking that, based upon.
No, but the sales here are most of these, the 4 closest, the sales are less than 200, 3 of the 5 are 200,000 and less.
And then one
very
is
small.
5 million.
There's a Behemoth there, and their sales have been pretty steady.
There's a Behemoth there, correct, $5 million, and as of June 30th of last year, they were $2.221 million. Now, my understanding is, again, not to restate what a previous attorney had stated, but from June to December is where the bulk of the money comes. That's where all the holidays.
No, they'll probably hit similar numbers. I'm looking at all the other stores.
And the other stores, again, the one that's here today, we did some research because my client was driving by. Again, he lives in the neighborhood, and it says grand opening. So I inquired last week of it, and it says that, yes, it's a new ownership. So that would, if that is correct, because we also tried to see if there was a corporate change done, because the licensee's name
Which one are
did
you
not
talking
change.
about?
I'm sorry?
Which one are you talking
Vintage. It's on the first page of the.
Yes, the third one. Yeah, no, that's been around since '98, and it's just a corporate change. So I'm not, even aside from that, I'm looking at Tech Evolution, which was licensed in April 2013, Multi-Star Wines and Liquor, which was licensed in June of 2012, and Massapequa Station Wines, licensed in September 2012, all within the last 3 years.
I'll agree with him.
Thank you for the board's time.
Thank you.
Sorry.
Have a pleasant day.
You too.
Thank you.
I'm a little late, but I tried to get them all for
1659 and 1665, 2945 Restaurant Corp.
Good morning.
Good morning.
Francis Buscemi for the licensee. This is a request to vacate a default against the licensee. I submitted the affirmation of the attorney who was handling the case at the time, Neil Visacchi. There was Mr. Visacchi, who was representing on the 2 cases, did put in a not guilty plea. There was a lot of back and forth with Mr. Buckley with regard to what happened. And this is basically seems to be a law office failure type of situation, miscommunication as to whether the case was going forward on the April 8th date. Or right after this default happened, within a matter of days, I did speak to Mr. Buckley to see whether we would be able to do this from downstairs without it having to come up to the board. Unfortunately, he was, he had indicated to me that he was not able to do that. I believe at one time it was a policy that they could do it if it was caught within a relatively short period of time, but he indicated that it would have to go up to the full board.
Send it back. All right. Okay, we have an affirmation letter here from Mr. Visacchi, and
Visacchi, yeah.
we'll send it back to council. I'll vote to send it back to council.
I'll vote as well to send it back.
Okay, that's for both.
Both of them?
Two cases. Thank you.
Oh, you might have that. It wasn't submitted.
Yeah, I probably already have it, that's fine. 1708, Melodia Corp.
So the offer is to cancel and bond?
Cancellation and bond.
I mean, the history here,
They have a prior, they have a prior case. They have a prior case in which I think it was something like a $10,000 civil penalty. I mean, was put in, which I think that's going to end up, and I think if it's not paid.
Revocation.
10,000, I think it's, on that case, I think it's revo and bond.
It's Revo.
So I have a feeling there's going to be a revo bond and a cancellation, you know, I
There'll be
mean,
no
whatever you want.
bond then.
They've been closed for a period of time now.
so for this, I'll take the cancel and bond, and we'll put a name stop on the premises and the landlord as well, landlord's name.
Sure. Name, prem stop.
I will agree with that as well. Cancel and bond.
Okay. 1714, 2260 Mag Corp.
This is after hearing.
Yeah, that's what I have. Charges were not sustained. I agree, I'll dismiss the charges.
Dismiss. Thank you.
Thank you. Have a good day.
Good too.
1717G, Inca Enterprises.
Good morning.
Good morning.
First of all, I would like to thank you to Jacqueline Hill for rescheduling to appear in front of the board.
You're welcome.
So I got.
I came here, it's my first time. I'm sorry, I am a small entrepreneur. I don't have money to hire a lawyer. I just come in because I think I wasn't fair to receive this notification. I have all the procedure that I already fixed.
Yeah, I think my main concern was you have a restaurant wine license, correct?
Yes.
And they found a bottle of Patron and a 1-liter bottle of Amaretto behind the bar.
That wasn't true. That was, that's why I was, first of all, I'm working away. I put Carlos Vildoso, who was taking care, I was paying him, but even I didn't know about when they received the first notice of I have to show up for this kind of.
So were you there or you weren't there?
I wasn't there.
You weren't there, but you know for a fact that there was no bottle of Patron or Amaretto?
Yeah, that wasn't.
How do you know? Do you have video cameras there?
No, but I have another person who works there.
And he or she said that there was no bottles, that
No
we just made
bottles.
this up?
No, it wasn't, because I have to take care of the
what do we do in
business.
that case here?
I have to take care for the place because it's something serious for me.
That's what I mean.
You want to weigh in?
She had pled no, well, what happened was you pled no contest, but if you're arguing that what is being charged wasn't really the case, that you did nothing wrong in that particular charge, then you want to go to a hearing before an administrative law judge who can help decide the facts. Is that something you would like to do?
Anything that I can fix it that, to prove that, because I'm trying to work
She doesn't have a lawyer, I feel like.
Yeah.
That's just
Well, ma'am, the no contest plea means that you're basically saying that you agree with the charges. So if you want to go to a hearing and deny the charges, then you can do that.
Okay, I was.
Otherwise, we'll impose a fine for the charges that are here, and you go on your way, back to your business.
Could you repeat again, please?
You can go to a hearing
Okay.
and present evidence and deny the charges, which would bring you back here at some point.
Thank you so much. I prefer to do that.
Or you can admit to the charges as they stand, and we'll impose a fine, and you can go back to work.
I'm not going to admit something that wasn't, it
Okay.
wasn't.
Then I guess
do
send her
it.
back.
Okay.
That's-
Yes,
I
because this is a
prefer-
very serious charge.
Yes,
Okay.
it is. I have experience.
Are you going to go to the hearing with a lawyer, or do you plan to just go by yourself? It's
For
your choice,
myself,
but
I
by
don't
yourself?
have
Okay.
money to hire a lawyer.
But you need to, if you go, you need to go in with evidence instead of, or with witnesses as well, as
Okay.
opposed to just saying it's not true.
Just to clarify,
thank you
we
so
had
much.
scheduled this for hearing.
Oh, we did?
This was scheduled for hearing,
And then,
and she proceeded to go, she decided to go forward with the no contest plea.
okay. Maybe you didn't understand the difference? Is that what happened?
Yeah, I didn't understand,
don't
so
think she
I'm
understood. Okay, so
sorry.
let's just send it for a hearing, because
All right.
she wants to, she's saying it didn't happen, so.
Thank you so much.
Okay, you're welcome.
You'll get a notice of the hearing date that you have
Okay.
to show up for.
Okay. There's any ways to contact, Miss, can I know who is Miss Jacqueline?
I am.
Okay. I
Yeah,
can
you'll
s-
receive a notice, just like you did before, about the hearing, a date, a time, and a place of when it's, where it's going to be.
Yeah, because the last time I didn't receive it, that's why I
That
was
was
worried.
here, but this
Okay.
is not, it's not mandatory here to
All right.
receive a notice unless you request it.
Thank you so
Okay.
much. Thank you.
Okay.
Have a nice day.
Good luck.
1663, KB Venture Group.
Good morning, Kerry Katsouris for the licensee. Mr. Chairman, welcome to the authority.
Thank
Commissioner
you.
Kim, Commissioner O'Brien. An application to controvert the finding.
You know, I sustain the charges and I'm ready to impose a fine.
I sustain the charges too. I actually agreed with the ALJ's rationalization of what went on here. So I'm ready to impose a fine too. I did read your controversion. So unless you have something to say otherwise, no?
Mr. Chairman, I respectfully disagree. However, I'm here.
Okay.
I have a fine of 5,000.
That's what I'm at, 5,000.
$17.10, Tony Ali and Associates.
This is an offer.
1710.
Kerry Katsouris for the licensee.
Every time you say Carrie, I look up.
Oh, this was untaxed cigarettes, and I mean, they've just been licensed, literally, and then they have 66 boxes of untaxed cigarettes that they're selling. You know, so I had 5,000.
I'll agree with 5,000.
I'm not doing so well.
That's a counteroffer.
That's a
Okay.
counteroffer of the offer of 3,500.
Okay, and this you too. 1717C, Cheap Shots NY.
This is an offer and compromise as well. I want to bring to the board's attention that these particular charges were withdrawn during a hearing, in which one charge was sustained and one charge was not. I didn't understand, for the life of me, why the charges were withdrawn and then proceeded on another case. And I just kind of thought that was kind of unfair.
Hold on. Good point.
Good point.
Okay. That's a
You might
question
be
for
good
you.
at this one.
Thanks for
Okay,
turning up,
back in April, the board had the hearing report in front of them regarding 5 charges. And you're just talking about the local regs
Correct.
and maximum occupancy. They have 2 of those charges for, with a data violation of 3/1/14. And those charges were drawn at the request of council. I do not that's all we had for, was that they were withdrawn at council. There was, I don't believe there was anything. The 2 they would be the,
Local regs and
the max occupancy, local regs, they were both for the same date, 3/1/14. I'm not sure what the second local regs is. Did we break out a particular charge into 2 separate? I don't know.
Well, charge 3 is also a max occupancy.
Yeah, that was
Yeah, so that was
Yeah,
withdrawn,
so-
and one of the,
On one of the other two
On
were
one of the
withdrawn,
local regs
okay.
On a different
One of the two.
proceeding. Do you know any, can you shed any light, Mr. Amarato?
It doesn't appear to be that they were charged for the same date.
for the local regs, it's just 2 of
3114?
them for 3114.
Let me check the pleading on that. You on case 96147?
Yeah.
So I think, you know, I'm for dismissing 3, the maximum occupancy. I'll accept the 3,000 offer on this.
I'll accept the 3,000 too. I think we should dismiss 3 as well.
And which was the other one? Do you know of the 2?
I don't know of the two. I don't believe the pleading differentiates just which one does it.
Can you tell, Mike?
I can't. All I
Can't?
have is 42115. That's all I'm seeing on this. For the
Just out of
dismissed.
fairness, should we dismiss
Reference on letter of notice.
4 and 5?
Yep.
Can
All right.
we second call this? Let me look.
No, we're going to dismiss 3.
Down to 3. One more.
It's great in baseball, right? 333.
Hang on.
What's the last one?
Is 1717E, Rain Nightclub.
This is after hearing, and I didn't move to controvert.
17E.
I asked for
Rain
compassion.
Nightclub.
No controversy but compassion.
All right. I sustain the charge, 3,500.
I agree with 3,500.
Thank you.
Thank you.
1685 Lucky 7 Deli Grocery. This is a request for reconsideration.
Good morning. My name is Shari Shimmick, and I'm speaking on behalf of Jagdish Singh, and this is Kapoor, Mr. Singh's manager. I'm sure that you have our letter of June 4th describing the events that took place during the hearings on April 21st and May 5th. I don't know if Commissioner Kim would like to recuse himself from decision-making because he was a witness to the events on May 5th, but we would like a
Witness
new
to the
hearing.
events? What event?
The hearing that took place on May 5th, which proved to be such a tragedy,
I wasn't at the hearing.
according to Mr. Madan, who accompanied
May
Mr.
5th
Singh,
was a
you were
board
there.
hearing. You mean here? I was here.
Yes.
But I was not at a hearing in front of an ALJ as a witness in any.
Well, apparently,
I walked.
Janique Green
Yeah, that's the other
conducted
commissioner.
the hearing, and
She couldn't have
according to
conducted
Mr.
Oh, you're talking about full board meeting? Okay.
Not a hearing. It's
All right, there's a difference in terminology. Hearing is it before an administrative law judge, and this is a full board meeting.
Okay.
So Commissioner Green and I were sitting on May 5th.
Yes,
Okay, so,
and since you were there, you were witness to the events that took place.
so it's a terminology. I don't think I was a witness. I was actually a decision maker, so I was, yeah, so
But apparently, Ms. Green did not.
Were you
permit
here,
to make a
ma'am, were you here?
I
don't
was
think
not
so.
here.
I don't know whether you're qualified to talk about what went on at that hearing either.
Well, I have the letter from.
As do
that
we.
Mr. Madan.
We
that-
do-
that
we-
Mr.
we-
Singh wrote.
we
and
do,
he was here with Mr. Madan.
Okay, let me just,
So actually, all we're asking for
excuse
here
me, I
is a
just want to
hearing.
clarify one point to you and to the members.
Yes.
Is even though we acknowledged at the board meeting, the first board meeting where they sat all day, I said that I didn't receive their number. Yes, we did take, responsibility for that. However, when I looked back on the sign-in sheets, your clients didn't sign in for a particular item. We should have caught it at the beginning as to what they were here for. They didn't indicate what they were here for.
Okay.
So that's to clarify, that was
Okay.
not intentional.
Okay, and the second hearing was apparently run solely by Ms. Green. She did not permit anybody to speak on behalf of Mr. Singh, and Mr. Singh was unable to present evidence, and all we're asking for at this point is to have a proper hearing.
Did they have a hearing? Or did
They entered a no contest plea.
He pled guilty to the charges.
He didn't plead anything because he was unable to get a word in edgewise.
That wasn't here.
That
This
wasn't
meeting is this meeting is to impose penalty. The hearing he would have gone to would have been in front of a law judge who would have allowed him to bring witnesses in and speak. That's not what this meeting is for. He could have pled three ways: not guilty and gone to hearing,
The hearing,
Conditional no contest.
Well, whatever it was he attended on June 5th, he said he was unable to speak.
But this is not the place for him to speak.
Ma'am, I have a letter signed by your client
Right.
dated March 23rd, 2015, which is also signed by Mr. Amaretto, who was prosecuting the case. And your client indicates in the letter, licensee offers a plea of no contest in connection with the case, with case number 102956, which is this case number.
Correct.
Sale to a minor that occurred on 12/4/14. That means he's pleading essentially guilty to this charge. He comes here
Right.
to be to get his penalty. That's the only reason he's coming here, once you plead no contest. If he didn't want to plead no contest, you go to another hearing that another judge does. They make a determination whether he in fact was guilty of that charge or not.
that date that he signed the offer was the date of his scheduled hearing. We had scheduled a hearing that date, so he had the option to go to hearing at that time, too.
That would have been his opportunity to speak and present witnesses, not at this meeting. This is penalty only.
So the only thing we can do, and that's only if Commissioner Kim agrees, is if he would like to have a hearing,
Yes, he would like to have a hearing.
he doesn't do it here. That means you
Okay.
come back another day
That's fine.
with,
I just want to point out that Sergeant Moles of the 5th Precinct was present that day. We were ready to go forward. I spent expensive time with the licensee explaining to him what his options were at that time, and he opted to plead no contest.
What day
He
was that?
understood what I said, and he responded to me.
What day was that?
That was the day of the hearing.
March 23rd.
March 23rd.
Yes.
Okay. That hearing I'm unaware of. I only know about the April 1st and March. and
Well,
May
I'm
5th.
fully aware of it because I was present.
Okay. Okay, well, he would actually like to have a hearing, and they've sent me here to ask that he have the opportunity to have a hearing.
Second bite.
I mean, huh?
We get a second bite.
No, I
does he
mean,
speak English?
Yes.
so normally we would give everybody an
Oh,
opportunity to be heard. But at this case, on March 23rd, they were there, and they spoke, and they decided not to go ahead with the
Here
hearing.
alone?
I wasn't there. I mean,
Did
why
he come
don't you
alone?
ask, are you the licensee?
No, he's the manager of the store.
Were you there at the hearing on March 23rd?
And
Were you alone, or did you go with the,
He
you
was
went- you didn't go with the licensee? Your
is your licensee here today?
No.
Was he at the hearing?
So who signed
He
who
signed
signed
it.
the license name?
What's who?
He was there March
He was
23rd.
there. Yeah.
He was there. Okay, so they were there. They both understand English, right?
Yes, but I
And
don't
they
think they
both
understand
decided,
our legal.
no, I know, but they had a conversation, right? And then they came here, and we apologized for the sign-in mistake, which is a clerical error. And I understand that they were very upset that they had to wait. And, you know, we are here to educate and help as much as we can. And I know in their letter to us, they said, you know, I mean, one of the things I think they just need to understand how this agency works. They said, why is there more than one commissioner? By law, the statute, there are 3 commissioners of the New York State Liquor Authority, and as long as 2 of us are here, we comprise the majority of the board, and we can have one of these meetings. And so we don't discuss cases outside of being in an open meeting like this. So when you said here, Commissioner Green was rude and your claims of what she did, and she wouldn't discuss with the other commissioner before she decided to vote, she has every right to do that. We don't have to have a discussion. We only can have a discussion in public in front of an open meeting, and that's why you were being recorded live right now, and this is in the archives. So you can go back and actually watch the May 5th full board hearing, and you can see how Commissioner Green and I acted at that meeting. Anyone can, anyone in the world, it's public access, go to our website. And then we can go ahead and impose at that time, because he had decided to plead no contest. And so even today, you're before us, you're asking us to reconsider our decision of what the fine we had imposed. And right now, what's before us is whether we give you that granting of the reconsideration or not. And I think that he's had sufficient chance and opportunity to go and plead his case at the hearings. He chose not to, the licensee chose not to. And what happened at that last meeting, we imposed a fair fine, and I vote
The
to
fine
deny
that was imposed was
reconsideration.
$6,500, which is $1,000 above the maximum.
The maximum is $10,000.
Maximum is 10,000.
Yes.
Per penalty.
Okay.
Per penalty, and the maximum penalty for a sale to minor, and this was his second sale to minor, is actually revocation plus bond. So even for one sale of minor, the maximum penalty allowed by law is for us to revoke his. There's no such thing as a maximum penalty in terms of monetary numbers except $10,000 per fine, per violation. So,
And this fine that was imposed previously was consistent for the second sale to minor, particularly under these facts.
Okay, well, nevertheless, the reason I'm here is to have a proper hearing, because apparently Mr. Singh did not understand his legal rights. He did not have an opportunity really to plead not guilty, which is what he wants to do. And so I was sent here in order to get this new hearing.
Mr. Singh was present that day, and as I said earlier, I explained to him what his options were at that time. And just so that you know, Sergeant Moulds was prepared and ready to go forward. Your client, or Mr. Singh, he opted not to, and he fully understood what I said to him, and I understand what he said to me.
Okay.
So if this is just a way to just, stall the inevitable, I mean,
No, from what I was told, that they possibly did not understand the difference between the.
Why isn't he here
coordinating the
today?
hearing-
Why didn't he come here today and tell me that he didn't understand the conversation I had with him?
No, not the conversation that you had with him on March
That's
23rd.
what this is about.
so basically,
What I'm referring to are the events of April
Ma'am?
21st, in which he did not have
Okay,
a
ma'am,
chance to
so
talk,
I think
and
we've
May
heard
5th.
enough, and I find that he had ample opportunity to contest this charge. He chose not to, and I vote to deny the reconsideration.
I'm going to vote to deny as well. Based on what you're telling us here, he fully understands English. He clearly signed this letter on March 23rd that indicates that he understood what he was signing and that he was pleading no contest. The fine is consistent with what's generally imposed for this type of violation for the second offense. So I don't think there was anything untoward that occurred here. I'm going to vote to deny the reconsideration as well.
Thank you.
Okay, thank you.
1717P, Northern Bell Plaza. I have no other people. There it is.
Good morning, Mr. Chairperson, Commissioner, and the board members. Michael Lee for applicant Northern Bell Plaza, 163-07 Depot Road, Flushing, New York. If I may, if I could begin by submitting a sworn affidavit of the applicant because his first language is not English.
Sure. Thank you.
Thank you. This is an application for reconsideration for cancellation order dated February 28th. The applicant pleaded no contest for the incident or the violation itself, but he sincerely requests the board to reconsider the cancellation order in lieu of the payment of full penalty at this time and allow.
Why didn't he pay?
No, looking at the affidavit, he was actually physically ill and also mentally exhausted because he actually is a recovering cancer patient, and he was actually during those time he was actually outside the country, and he did not realize that his license was in jeopardy because he left one of his employee in charge to maintain.
So he was not going to pay until
No, he was going to pay, but he did not receive the penalty or at the time because it was mailed to his home residence, but he was in and out of the country trying to get treatment for his skin cancer. Now he's fully committed to paying the penalty even today because he has.
How long was he out of the country? We're talking about.
No, he was out of country from, I believe that February, the middle of February, and he received the cancellation order when he tried to submit the, what do you call, the renewal application. It was not his intention to actually not to pay or trying to make a contest. He's fully prepared to actually plead no contest to the charge. And it should be also noted that, he has a vested interest in this business because he was once actually the landlord for this property. And now the property is sold to third party, but he kept the business because he has a vested interest and he wants to continue to the business in the neighborhood.
What's your case?
Well, we imposed the cancellation because he didn't pay.
Yes.
The original fine was $6,000.
Yes,
and when did we mail out the notice
We
then?
mailed it out?
March.
Let me get back on that case. The notice for the full board disposition went out on February 9th.
February 9th, and you said he was out of the country?
Yeah, there's a copy of passport. I actually attached the affidavit. He came back to the country on the March 1st.
March when?
March 1st.
He was out on February, like in mid-February then at the time?
I received an email on March 4th from Mr. Park, and it was due to financial hardship is why he didn't pay the fine at the time.
That's when
But there's nothing in the emails to indicate that he was out of the country.
That's why.
And we might have taken that into some consideration, but I have nothing on that.
And sir, the other problem I have with this is that he defaulted on the charges. He didn't show up from my understanding. Am I wrong with that, Jackie?
No, he defaulted.
So he didn't respond to anything until we canceled him.
Yes. There's lack,
And he's had other charges before, other violations, so he knew he was supposed to respond.
Well, he defaulted on that charge also.
basically there's two charges, which is defaulted, yes.
Well, so who's in charge of getting his notices, and he is?
He is.
Well, obviously, it's not working, right? That's every notice that goes out. The
Or
only,
he's throwing them away, one or the other.
all right, I mean,
Of note is that the license did expire on 2/28/15, and the renewal for the, this 2-year, for the 15-17 license has been disapproved.
Yes.
based on this?
Based on the cancellation, yeah.
I mean, the only thing is, given that he was getting treatment for cancer, and if he was out of the country doing that during that time of the last notice, that's the only reason why I could see giving one more chance. But the fact that he's not responding to the notices,
I mean, number one, that with the affidavit, he's trying to make, I guess, amends or improve the, I guess, operation of the premises by retaining a security guard in the future. If you want to stipulate that, he will stipulate to having security guard and presence.
was that in his method of operation?
No, it
As
was-
original? So he's going to have to change,
Yes,
file a
that's why
change?
he's going to
Okay, you
stipulate.
can do that.
He's got to start running a business like a businessman. That's what he's not doing.
He's got to get a lawyer to maybe, or not a lawyer, he's got to get somebody who is in charge of responding to notices from all the agencies and regulatory agencies. You know, given those circumstances, I'll grant the reconsideration. Do we impose the fine
I
still,
mean,
though?
we are prepared to pay the fine.
And
was
require that the
today.
fine be paid, you can pay today?
Yes, I brought.
And require that
my-
the payment be made today?
I'll agree with that.
And it was fine.
What's that? It has to be
Yeah, the-
certified check.
And while he's
Oh, is-
here,
is
you know,
it-
there's
is it out
been
of your account?
two sales to
Attorney? I'll
minors.
take that, attorney.
There's been two sales to minors.
Yes, we understand that.
It's very, the penalties get very severe.
Yes.
Third one and beyond.
Now, would he be allowed to then resubmit the renewal application?
The renewal application, how do you want to handle that?
Yeah.
Because the fee was,
It was a return.
the fee was, there was not, we didn't process it because
Yeah,
the
it
check was either stop payment or was returned for insufficient funds. Stop payment, you stop payment, the check.
We could make the whole, renewal application we submit within a couple of days, but I've been prepared to actually.
Escrow check. You
Attorney
can
escrow check, I'll take it, yeah.
Yes. Will be the fine, sorry.
Go, you can.
Yep, you can go talk to me.
Thank you.
Because that'll be in the next one. 1717F, it's a request for a ruling for, I think, a mobile app named Thirst.
Morning, Chairman Bradley, Commissioner Kim.
Good morning.
My name is Alexander Victor. I'm the attorney for Thirst. This is Purvi Shah. She is the creator, founder, and owner of Thirst. I'd just like to start by thanking Ms. Flug. I knew that she couldn't be here, but she spent a fair amount of time with us to discuss this matter. And I'm also aware that she submitted some comments to the board, which I'd like to address, but I'd first just like to give a brief background or overview of what Thirst is and what Thirst does. Thirst is a mobile marketing and payment application. It allows a user to view different venues, to browse their menus, to order food and beverage, and to pay for those items through the application. A venue that wants to participate with Thirst would choose the food or beverages it wants to promote, and those items would be loaded onto the mobile menu at the same prices the venue otherwise charges on its printed menu. Our written submission goes into greater detail about the service and payment logistics, so I wasn't going to discuss that now unless you would like. I just want to point out that the service and payment and the terms of that comply with the prior rulings of similar third-party applications, in that the licensee retains complete responsibility and control over the service and selection of products, and all payments are reconciled or processed on a timely basis between a consumer's credit card company and the venue itself. Conceitedly, Thirst is not the first mobile marketing payment application, and the authority has previously approved an application called Slinger. We reviewed Slinger and see our proposed operation is quite similar, although Slinger has a different fee structure that was approved. Slinger was approved for a fee comprised of a fixed amount plus a percentage per order. And what we are requesting here is a percentage fee only, which would never exceed 10%. Our understanding of Council's comments is that there's maybe a concern that if Thirst were approved for this fee without requiring a consumer to purchase food, then there may be some inconsistency with prior rulings to Groupon and Living Social, which required food to be in packages with alcoholic beverages. We reviewed those hearings and rulings and really did not see how an approval for Thirst would have any bearing on those matters, because Thirst is not a discount or coupon service. And we feel that this distinction is important because it's the discounting of alcohol that creates the potential for a licensee to violate the law regarding unlimited drink offerings. However, once you include food in a discounted alcohol offering, there's no risk of violating the statute, which exempts packages of food and alcohol. For this reason, Groupon and Living Social were required to include food in their packages, while Slinger was subsequently approved without such requirement. Thirst, like Slinger, will always have the capability for a user to order food through its application, and Thirst, like Slinger, will not discount the cost of alcoholic beverages. Accordingly, we see no reason to predicate an approval here on a requirement that a user purchase food with a drink, and we do not feel an approval here causes any inconsistency with Groupon or Living Social.
Well, the first inconsistency would be the percentage that it's 10%, is that correct? Whereas Slinger opted for 25 and 25 cents, is that correct?
Well, Slinger is 25 cents plus 2.5%,
which is
of
considerably
every
less
item.
than 10.
It's less than 10%, but when you look at what the cost of the item is selling for, Slinger in many cases, and it's not in New York to our knowledge, but we've looked at where it does operate in California, and many of those restaurants or bars offer drinks for $3, and at that price point, Slinger's getting 10% or more of the revenue of the alcoholic beverage. Here, we're capping it at 10%, so there's never any risk of us getting what could be deemed a substantial amount of the licensee's revenue. It also doesn't, factor in the fact that Thirst is not making every sale for the licensee, so on an annual basis, Thirst is getting much less than 10% of the licensee's revenue. I reviewed Living Social, and they were limited. Well, they had a variety of fee structures, but one of their conditions was that on an annual basis, they would never have more than a 10% interest in the annual revenue of a licensee.
They were also providing food.
They were also providing food, but their percentage, I think, in each coupon was greater than what we are getting in each deal. So their percentage, whether it's a percentage of food and alcohol, still boils down to a percentage of alcohol. The other consideration for 10% is that, as a matter of practice, I know that landlords or a licensee is granted its license even where a 10% of the revenue is going to the landlord as rent. And last week, there was Swill, and although it was phrased as a flat fee, assuming a substantial number of its bottles will be sold at between $10 and $50, Swill is getting between 10 and 50% of just liquor revenue.
Would Durst consider taking a lesser percentage?
We will certainly be taking a lesser percentage as we get started. We just want to know.
I think whether Thirst takes a less percentage would be negotiated with each venue at an arm's length deal, but having the ability to get up to 10% is consistent with prior rulings. And
not exactly. It's not exactly consistent with prior rulings. There are differences.
So in Swill, where a company was getting $5 of, let's say, a $20 bottle, that would be roughly 25% interest, although they call it a flat fee.
Well, but now that's a flat fee. I realize that in that instance on that sale, that percentage is higher, but technically they're not taking a percentage guaranteed.
No, they're not. So what I think the benefit to Thirst is that it's capping any revenue at 10%, whereas with other applications and other third parties, they would be getting a certain fee, which in many situations would exceed 10%. And on an annual basis, when you exceed 10%, to my knowledge, that's when the authority considers it more of a substantial interest. And at 10% or less, it's deemed not substantial.
I mean, we've approved, from my understanding, up to 10%, but it was combinations. And you're talking about you want to be able to do it without the combination of food and alcohol.
Those are also discounting services.
Right.
The sale of alcohol, and we're not a discounting service. We sell the same price that the licensee sells.
And it was not necessarily 10% of any one deal or sale, but it was capped at no more than 10% of the licensee's revenue on an annual basis. To my knowledge, Groupon Living Social get a 25 or more % interest of the coupon sold.
This, the free items that a user gets when you visit or what does it say? Who visits a venue between 8 to 25. Can they be alcohol? Can you come to the mic, please?
Sure. They are determined by the venue. So essentially, they get, we keep track of the number of dollars spent at a particular venue, and based on the venue's discretion, they are able to gift as loyalty to that customer a free item of the venue's choice.
Venue's choice. And I would think a lot of times it might be just alcohol. The Thirst menu can have food on it, but it wouldn't normally. It would just have drinks. And then for the profit margins for a restaurant or business, just alcohol is going to be the cheapest or the best profit margin for them. So
generally also we want to consider the idea of the 2-for-1, which is within SLA regulations. However, we're looking at something that's more like a 10 or 25 for one. So it's a different ratio, and we're trying to be very conservative with that ratio. It might even be more than that. It really depends on what the parameters of that particular venue are.
Is this service going to be available to all, say in a particular area, if every restaurant in that area wanted to participate? Are you going to permit that, or are you picking and choosing what you're going to who's going to participate?
Obviously, they need to be in good standing with the SLA. They need to have a properly run business. We need to make sure that their venue staff that we feel like they're representing us very well. So that's basically at our discretion that we would make sure that they are proper venues to be able to bring on to our platform. But certainly we would consider any venue that wanted to come on board as long as they were within good standing.
So somebody places an order through via Thirst on their smartphones, go to the premises, a photo of the user that gets sent to the licensed premise, but is the photo the actual driver's license, or is it just any photo, like a Facebook profile photo?
It can be a Facebook profile photo. It can be a photo of that user. The bar staff.
But then the licensed premise has to confirm and accept the order before they actually come face to face with this person.
No. The customer still has to show their confirmation screen, which is on their smartphone, to the bar staff or the venue staff.
And then at that point, the licensed premise then
Check their
accepts it?
identification. They would check their ID at that point and then confirm it.
I see. So, because I thought part of the allure to this model was that, I'd be walking down 3rd Avenue and I'd be looking around the area for different venues that might have the type of drinks or food that I want, most likely drinks here, and I say, oh, well, this place has this great cocktail. So I put in the order, and then that person, so the bar or the licensed premise hasn't accepted my request yet. It's just that I put it in first, though, at that time before I go in, or I have to wait till I go in and I put it in?
Either way.
Okay, so let's say I put it in, and then I walk into that bar, and I go to the bartender. Then I would show them my confirmation page with my photo, whatever's photo is associated with the app, and then I'd have to show my ID.
Yes.
And the bartender would then, at that time, confirm the order? So they don't confirm the order when I first put it out, when I'm out on the street, right?
Absolutely not.
Okay. Because that would disincentivize them to possibly be as vigilant in checking if they've already got the order in.
Absolutely. No, we want to make sure that they're still completely needing to do that. That's part of the flow that we will explain to them, and that's part of our training to venue staff, of course. And we also try to have fail-safes within our application, which is not to say that they should be any less vigilant, but we also make sure that through Facebook and
Right.
through the App Store that we maintain age restrictions there as well.
How many, are you operating in other states right now?
We're not operating. We're waiting to get our ruling.
No, in other states, though, or, no?
Yeah, I mean, the free items, which will most likely become drinks, in my opinion, that does constitute somewhat of a discount model, similar to Groupon and Living Social. It might not be 2 for 1. It might be 8 to 1, which.
But I would just point out that that's basically up to the venue's discretion, and it's not a model or program that all venues are subscribed.
We're not paying
Well, it
for
says here the venue would be paid for the item by Thirst. Is that wrong?
No, it's when it's a gifted item, something that is, say, I am sending you a drink or a food item because it's your birthday, I've missed your event, so I can send you a burger and a beer, for example. In that case, me as a sender, I would be paying for your
Sure.
gift. However, the venue is in complete control of whatever sort of loyalty reward program item.
And they would foot the cost of the item.
Exactly.
Thirst doesn't do it.
No, we do not do
Okay.
And so it's completely up to them as well if they would like to participate in that program or not. It is not a requirement.
I'm not following you, then. There's the gifting that you, as a friend of mine, could gift me if you knew I was at this location, which obviously there's not a problem with that. There's other gifting that the retail location could actually buy a drink for me.
It's a rewards program, essentially.
But is it a rewards program for using Thirst, or is it a rewards program for being in the restaurant?
For loyalty to that particular venue.
Okay.
It would be as if I were a known customer to a restaurant and they occasionally sent me a free glass of wine.
So you're going to keep track of that for the restaurant? Okay. Okay.
All right, but that's through Thirst 8 times. I mean, I could go 6 times to that place and not use Thirst, and I wouldn't qualify.
So it's kind of a motivation to use Thirst?
Right.
Well, I would say it's also a motivation for the venue to maybe do it because now it allows them to keep track and know who their customers are.
Yes.
Right, data tracking, yeah. But my point is that at some point that is somewhat of a discounted model because, you're getting 1/8 off after 8 visits, right? if you accumulate all the drinks that you're going to get.
In theory, I would say you're right, but when you get to one for every 10 drinks or 10 meals or 10 whatever, it seems pretty insignificant. As you said, if alcohol is the big profit driver, then you might be more likely to send over a free dessert than a drink which they can make more money on.
No. For the cost basis for the store, the restaurant, and the bar, drink will be a lot less cheaper for them to take that beer on tap and give it to you as opposed to them giving you a dessert. So if the venue is bearing the cost of this, 99% of the time, if they do the numbers, if they're basing their decision on an economic, rational basis, they will give you a beer or a glass of wine.
Okay, but in any event, it's allowing an application to keep track of what the bar would probably already do. If I were known at a bar, I'd imagine that most would give you a free something once in a while. And then the bar is not operating on a
You
discount
should tell us which
method.
bars you go to, because I mean there are obviously when you build up a relationship, but 8 times I don't necessarily think they're going to give you a free drink just because you're there 8 occasions ordering 8 beers.
Again, but
each
that
time.
would be that would.
Anyway,
look
the
up to
point is
venue.
that my point is that you were trying to distinguish Groupon and Living Social in the fact that they were discounted programs, and therefore this is different from that. And I'm saying because of this loyalty program, because of this 8-to-1 to 25-to-1, whatever the range is, because of this feature on your app, it does liken it to, there is some sort of discount, not as great as Groupon or Living Social, but
People are buying a coupon for a restaurant because it includes a package of food and beverage for $50 that would sell for $100. I don't think that those same people are running to Thirst to subscribe and go to the same venue and buy 10 drinks just so that they could get the 11th on the arm. To call it a discount model on
no, I get it. However you call it, there is a discount to the.
Yes, but it
there is a
seems-
benefit that's equally. You save money because of however you do this, and that's to me is some form of discount. But okay, we can. Sure. It's not required. I get that. Got it.
And even with that discount, there's no chance that a venue could violate an unlimited drinks offering by giving one for every 10. With Groupon or Living Social, that was a concern, if the drinks were discounted more than 50%.
All right.
Or is it different visits?
Sorry?
Is it drinks in one sitting as well?
It
or
would,
has to be
it would
one-
keep track over the history.
Oh, 8 different visits. Yeah, visits. They want you to come back.
That's another worthwhile distinction, that Groupon and Living Social use a Groupon for one visit. Here it's usually, it would happen, I assume, at least over 3 or 4.
How are you getting the 10%? Is the money's all being handled by the retail establishment, and then it goes, they have to pay you?
We process the payment, so we are basically a credit card processor. The funds roll over directly into the venue's merchant account.
Okay. And then the 10% or whatever the percentage is gets sent back to you? Exactly. Okay.
I mean, it's really, we had just recently ruled on Slinger, and the flat fee and 2.5% for alcohol only seem to be the reasonable limit based on our other rulings before that, and that was prior to my time as well. And so I think it's just been a kind of a continuation of the precedents that were set. Obviously, we're not tied to any of the precedents. It's just a matter of, for presumably, potentially an alcohol-only third-party provider, is there a certain percentage limit that we'd be comfortable with beyond 2.5% and 25% flat fee? I think the flat fee requirement has been pretty consistent because of the more, I think, perceived ownership interest that somebody has when it's just purely a percentage base. So it's kind of where we're at, and 10% has been also this number that we've been using that delineates substantial ownership interest or interest in a licensed premise.
I would just like to reiterate
Sure.
that-
You can come to the mic, please.
Sure. The possibility of us taking every single sale, processing it through Thirst is very, very unlikely. At best, I would say we would be processing maybe 20%, more realistically, about 6 to 10% of a venue's entire transaction volume. So if you're looking at that and you're concerned about an annual revenue for a venue, then you're really only looking at about 1% of a venue's entire revenue. We're never going to be able to compete with
It's just a
credit cards.
pessimistic view of the business.
I'm being very realistic. I mean,
Well, what's your, as far as your business plan goes, what's
Sure.
your hope?
What's my hope?
Like, what would be your
Yeah,
expectation?
about 20%.
Would be the maximum expectation?
Yeah.
Whatever we decide will affect, in some ways, Groupon, Living Social, Slinger. Yes?
I think there's enough distinction here that it would not affect Groupon or Living Social, but as I understand it, each of those rulings are specific to those requests.
Sure.
I mean, I don't have a problem with it. My only problem is really with the percentage. And you make a good point that you're only going to get 20% of the sales, you hope. So it might be significantly less than that.
Would you consider putting food items on, just as Slinger did?
Absolutely.
But as a requirement?
As a requirement, I can't require the venue to.
I would think they would want to get more stuff on the,
Each.
I really have to maintain full control for the venue. I can't control what I'm telling them to put on the menu.
I would just point out, even if the venue were to decide that they didn't want to list food, a user using this application would have an option to order something off of the venue's regular menu, which must otherwise order food through this app.
and Slinger did include food items on the menu, although nothing prohibited a person from simply purchasing alcoholic beverages.
That's why I didn't see a distinction in that.
You didn't see any distinction?
Because they can just order alcohol, that's why.
Right. So what percentage would you?
I was thinking more like 7.5 or 8.
I mean, I was initially thinking if we're doing 10% for Groupon and Living Social with food and drinks combined to kind of split it more down,
can do
maximum
that.
of 5%.
That's fine.
Or 4% plus a flat fee that doesn't require, that doesn't exceed 5%. That's one of the proposals I was thinking. I wasn't
When you
set
say
on it.
that Groupon and Living Social are combining food and beverage, that's true, but they're still getting a percentage of the total package, and that includes liquor. So if they get a 25% interest in the food and beverage, they inherently get 25% of whatever the liquor is being sold for.
And inherently, a lot of times,
Can you speak into the mic, please?
Groupon and Living Social, oftentimes they actually split it 50-50, where they get 50% of that sale. And I think the concern was 10% of total revenue annually.
I think it's a lot harder to also regulate on an annual basis. I understand that that's what we've been saying. And, on a per sale is a lot easier to regulate because on every transaction you can see if there's a violation that's occurred. So from a regulatory perspective, I think that might make more sense.
Then if it's up to 10% per transaction, it could never go above 10% on an annual basis.
Correct. Or if it was 2.5%, it could never go above 2.5%. But yes, whatever percentage we
I think
settle
they'd
on.
actually do better on your 5 plus a flat fee than they would at
Plus
7.
a flat fee? I actually meant up to 4% with a flat fee that doesn't exceed the 5%
Oh, I see.
total. If you do, it's true what you said also before about Swillow or some of the other, a Slinger, I'm sorry, if a alcoholic content, if a beer costs $3 and they got 2.5% plus 25%, it would actually exceed 10%, and there are cases like that.
And
Although $3 beers in New York is a lot harder to find than the
we
ones
did
you
look
found,
them
but-
up, and they're a a
No, I
lot
know,
of
there are
places
places that do happy hours and whatnot. to do that,
and
so.
less than that. Instead of the potential for getting above 10%, we thought limiting it to 10% was more than consistent with the prior rulings, consistent with, the practice of a landlord having a 10% interest.
So I think we're okay with the food not being a requirement of every sale. I think that we're in
Yes.
agreement on. I think it's just a percentage, and there is a good argument for keeping it, as long as it's, I wouldn't say exceeding 10%, I would say below 10%, so 9.999, right?
Okay.
That's in my opinion, but
Throw a number up there.
you thought 7.5%, 8%? I think if we're going there, just keeping it at maybe a 10% max, and then
At least that would be consistent across the board.
If you want to go
all
there,
right,
go there.
all right. So I'll approve, or my. Are we making a decision? Yeah. So I'll approve the 10%, up to 10%.
I agree with him.
Thank you.
All right. Good luck.
Good luck.
1679, Pico de Gallo.
Say that again, Jackie, I'm sorry.
1679.
Must be almost time for vacation, he's waiting.
Yeah, we have. Big time.
Good afternoon.
Good afternoon.
You can just introduce yourself, please.
My name is Pedro Zenteno.
Thank you.
Did he introduce himself?
Not yet.
This is an application for an upgrade for an existing wine and beer
Could you
license.
introduce yourself?
My name is Frank Palillo.
Thank you. So the community board is a 500-foot hearing, 500-foot case, and the community board is very much against your applicant's application. Do you have anything to say?
Yes, Commissioner Kim, I actually when you say the community board's very much against it, the community board held a meeting. They indicated that there were 8 on-premises licenses within 500 feet and told us, no more, we're not doing any more.
Well, I based it very much on the unanimous vote.
We never even had the opportunity to actually present what we were doing here. They knew this location. They indicated they had never had a problem or a complaint with this location. I know for the record that there are 8 licenses within a 500-foot radius. 7 of them are bars. There's 1 restaurant, and will be the 2nd restaurant in that 500-foot location. Additionally, this premises has had no issues with neighbor complaints or with 311 calls, certainly not SLA that I'm aware of. And we think that there's a thriving neighborhood that this restaurant will serve.
How big is the bar that he wants to put in?
If you give me 2 seconds, I can.
Approximately, I'm not going to hold you to it.
Yeah, but I want to be exact. 18 feet 7 inches is 12 by 6.
And how many seats, are you going to have seats at it? No seats?
This was the cashier's counter.
Right.
We're just converting it now to the bar, but there's no seats at the bar.
So it's not going to operate as a bar. This is solely for your restaurant.
Correct.
And what are your hours?
Oh, it's
10 to 4?
10 to 4? Yeah.
Do you turn into a club at night at all? Is there music?
No, it's just restaurant.
Any recorded music played?
No background music?
Well, just the music that we play from the machine.
No DJ? What about the other restaurant in the area? Is that open till 4 a.m. as well?
Not sure.
That would be Pequeña Colombia. Do you know if they're open till 4 a.m.?
No, I'm not.
What's the address, Frank, do you know?
8327 Roosevelt. Now, he's built over the course of a little more than a year now, a thriving business that's going till 4 a.m. without being a nuisance to the neighborhood or without being a problem.
Is there anything in there regarding complaints, Karen?
They better not be.
It's only been in operation for a year, but so.
15 months, yes.
Yeah, 15 months?
No, I'm sorry, 13, you're right.
Yeah, 13 months, and he's had no adverse history,
We have nothing. No complaints.
no complaints. All right, I mean, we want to reward good operators, so I'll vote to,
Yeah, I don't have a problem with it either. He's got a wine license now. The fact that he's telling me there's no seats at the bar would indicate to me that it's not going to be a bar, so as long as it continues in that direction, then I don't have a problem with it.
Thank you.
Okay.
Wait for me.
1717O is Deacon Brody Management.
It's an offer and compromise. My name is Frank Palillo. I have with me
Glenn Falcone.
the general manager of the premises.
there's a workman's comp issue on this as well.
We had it, there was apparently an audit that was done. During the process of the auditing, the state insurance fund canceled the policy and we didn't know about it. We have since reinstated it, though. I do have proof, actually, if you care to see it. I can
How
stand
long
up
was
here
he
and just
without
say
it?
Do you know how long? Oh, I can tell you. From December 16th, I think, till January 11th. December 12th to January 11th, 1 month.
1 month? All right. All right, I'll accept the offer, 5,000.
I accept the offer as well.
Thank you.
1662 IGI Restaurant.
So late renewal, the fine's been paid.
You know, the offer said $1 on my sheet, but I assume it
That's
meant
on mine.
1,000, right?
That's supposed to be a comma.
Okay, so
Where do I go to get a refund?
I accept 1,000.
Don't call me.
I accept as well.
Thank you.
Okay.
Is that it?
Hi, are you here for a particular item?
Oh, they're just visiting me, actually.
they're visiting
Yeah,
you?
they
Okay.
just stopped in, so.
Oh, that's nice.
All right, I have no other items signed in. We can continue with the remaining items, if you'd like. Starting with 1656. Did want to make an update on the agenda sheet. At the last board meeting, the members voted to cancel the license on, and combine two disciplinary proceedings for minors and noise nuisance health regs, fair display, security guards, et cetera. So that cancellation will be imposed soon.
So do we just, for the record, cancel for the record?
Yeah, there will be no bond
Okay.
available. Okay. 1657.
6,000.
I'll agree with 6,000.
1658.
I had, the money wasn't received, so cancel and bond. Did we get the money ever? 1882?
They maybe, they surrendered the license. They did not replace the funds. However, they're offering $500 to settle up with us for the most part. I mean, if they paid
that-
the fee and then they surrendered, and then we'd
Were
get
they
into
open for any length of
prorating and refunding.
But they paid the fee, or they never did? So
No, they
then it's a
surrendered
can-
the license instead.
Right, so cancel and bond and
So counteroffer.
counteroffer. Because that's under our guidelines, if it's over $500 and it hasn't been replaced.
But that's money that we might get in lieu of
Yeah,
the
they-
funds for actually working.
We're not going to get anything at the end
Yeah.
of the day.
The surrendering the license
Oh,
is
they
the
surrendered.
variable.
Okay, all right, I'll accept.
Okay.
I accept.
1660, I have a
Workman's
request for
comp.
counsel's office to be returned.
Workers'
Yes.
comp? Yeah.
Good.
Yes.
1661.
Cancel and bond, accept.
I accept.
1664, I have a request to adjourn to 8:17.
We don't have 817, right? 811?
No.
No, you changed it.
Oh, I'm sorry, 818 and
Eight-
19.
Hang on, 18, 19. Yeah, I think I put the wrong date down
Yeah,
here,
it's-
sorry.
So what's he want, 818?
The next meeting, well, he actually wanted 8:11, but that's not going to happen. Let me just get my calendar back up, sorry. Yeah, the 18th and 19th, sorry.
So 818.
18. 1666.
They didn't have food, so unless they have food now, bring them in.
Let me see if they had any other letters in there.
So what are we doing with that if we bring them in? We just send a letter that you have to appear?
Yeah, and tell them they have to serve food, or you can just cancel them.
Cancel's a little extreme for
Yeah.
the first one, so.
Yeah, they don't have
Just-
any
but
history.
sometimes they don't know, but.
You can call them in, and if they don't show up, we'll cancel
know?
them.
They submit a menu with their application every
But,
time.
yeah, I think they need
Send
to,
them a warning along with the, if you,
and
whatever
then impose a
penalty.
fine and just do a warning. Okay, let's do
warning
that.
them
Let's
up to
All right,
impose a
$40
all
fine.
right, yeah,
All right, I'll-
$3,000 and
Yeah. And a
send a
warning.
warning letter about the food.
Agreed.
1667,
There's two offers, so it's combined 4,000, accept.
well, in order to.
So
if
accept,
you-
charge one 2,500, charge two 1,500, like
Right,
that?
and then
Okay.
they're going to apply for the ATAP, and then they
Okay.
can do it.
Yeah, well,
I accept.
1669,
offer 1,500, accept.
Accept.
1670,
So now, they did the ATAP, 7 ATAPs. Are we limited to a certain amount, or is that?
no, what I do is, we're telling you that they submitted how many ATAP certificates they submitted. One, if it's a restaurant and they only submitted one, clearly not all their employees have been
Right.
ATAP certified.
Right.
It also allows my staff, when we go through and they want the reduction, then we'll make sure we have
So
comparisons.
if I impose the 3,500, will it get
It'll be reduced by
lowered
25%.
because of the?
Yep.
Okay, all right, so 3,500.
3,500.
1671,
So it's kind of the same thing, but their offer's 1,000, so.
because of this is where the clerk was trained prior to the sale?
Oh, I see.
for
So
this-
that's the limit then.
The
We're
limit.
Okay,
legally limited on that?
Yes.
Prior to this, oh, got it.
1672,
I'll accept the offer of cancel and bond.
I accept.
1673,
Charges 1, 2, 3, sustain, charges 4, 5, dismiss, 2,500.
I agree, 2,500 for 1, 2, and 3.
1674,
Charges sustain, revoke and bond, previously revoked, but he got his license somehow
no, it was revoked at another location.
at another location, but
So-
yeah, I still,
So we would revoke this or cancel?
Either or.
Okay.
I'll revoke
All
it.
right, revoke.
Okay. 1675,
Offer of 3,000, accept.
Accept.
1676,
Offer 4,000, accept.
1677,
Offer 5,500, accept.
Accept.
1682,
Cancel for the record. And charges are sustained, right? License was already canceled.
is already canceled bonds, the bond's exhausted.
Yes.
Okay.
What, did you cancel for the record?
Yes.
Yeah. 1686,
Offer of letter of warning, I don't know why they.
They went there for a sale of minor, they didn't sell.
They didn't sell? Okay, all right, I'll accept.
Well, what was the, hold on a second. Okay, yeah, I'm fine, I accept.
Sorry, go ahead.
that's okay, no, but, sorry, I was trying to catch you in between the, 1687,
Cancel and bond, I had.
Counteroffer?
Yes. CB9 had a stipulation to stop serving at 1 AM with them, but at 2 AM they were serving minors.
I'm fine with it.
Okay, counteroffer, cancel and bond. 1688 and 89,
I had a counteroffer of 12,000. There were 3 were under 18. There was a large fight. The other sale to minor was on 18 years old.
The evidence is kind of light.
I had
Is
a
it?
counter of 7,500, I split the difference, was it
All right.
12?
Yeah, because I was adding, all right, so. All right, we can go
9,500?
9,500. I agree.
I'm sorry, 95.
9,500.
Mm-hmm. Okay, I had an email on this next item, 1690 and 1691. Just bear with me. Received emails this morning. Of course, now I gotta figure what I want. Donald Bernstein. He didn't realize he had items on, but he can't make the meeting.
Okay.
There were 4 charges, one for lewd and indecent. He's just, was not found by the not to be sustained. Got it. Relates to not having certain permits. We agree that we did not have an open flame permit. Since then, a permit has been applied for. The second, there was a security guard roster. However, the manager had difficulty finding it. By the time he did, the officer had left. 3 and 4 were for dancing without a cabaret and a sale to minor. I would have little to add by appearing today and would in any event request a monetary penalty. Technically, he's doing his controversion and request for a penalty.
So there's no adverse history, and they've only been licensed for...
Oh, that
this
is
was like
wrong.
completely wrong, right?
It's not even
Oh.
2016 yet.
Right.
Yeah, it's not that.
So, but they have no adverse history?
The time is off on this one. Hold on.
And it seems like the first event was a private party, or the first 2 charges sustained.
That's not even right.
There are pending charges.
I'm going to say it's around 10 of 2012.
And
They were licensed.
2012, but they don't have any adverse?
They have pending, they don't have any.
Pending, but
Pending.
before this, they didn't have anything?
What's pending, Mike?
104291 disorderly premises.
No, that's on here. 104291 is on here?
Yeah, there's 2 proceedings
Oh,
on
I'm
here.
sorry.
It's 103903.
All right, if they don't have adverse.
There's a fair
03
amount.
is not on there.
Quite a bit, yeah.
103903, failure to comply.
Okay. All right, well, I mean, based on what's before us, I'll dismiss charges 1 in the first proceeding, 1 and 3 in the second proceeding. As to first proceeding 2, 3, 4, charges 2, 3, 4, and second proceeding charge 2, I'll do 6,000.
1692.
I have 2,500 because of their history, no adverse history.
Because of their,
Right.
since 1980, no history at 2,500.
Not necessarily as close. 1693.
Sorry, I didn't, what did you have for this one? No longer open.
Yeah, I have cancel and bond.
Cancel and bond.
1694.
The license was surrendered, cancel and bond.
1695.
I mean, they did the violation under a temporary permit.
Mhm.
No,
And the clerk who sold it was already ACAP?
so is that,
Bad move.
is there a limit to that if they're doing it under a temporary permit?
No, that would be a council question.
Sorry, I didn't hear it. I didn't hear you.
If they're operating under a temporary permit and the clerk held a valid certificate of completion, do they qualify? Are we limited to $1,000? That'd be under 6.
I would, under a temporary.
5.7A.
Say not.
Not? All right, I'll do 4,000. I'll accept their 4,000 one time.
I'll accept 4,000.
1696.
Offer of cancel and bond, accept.
Accept.
1697.
Offer of 250, I'll accept.
I have a question.
Mm-hmm.
Unlicensed from 11/114 to 12/515, is that no liquor license?
Yes, we wouldn't, because they didn't give the proper notification, we wouldn't issue the renewal until the 30 days were up. They didn't submit a waiver because they had to give the 30-day notice.
So were they open and selling for that year? That's a year.
Oh.
12/515 hasn't happened yet.
That's a year.
Oh my God, 14.
It's a
Got to work on
typo.
this, I'm sorry.
Is that a typo?
That's a typo, right?
Yeah, 12/515 hasn't happened yet.
Okay, then I'll
Yeah,
accept, yeah, good point.
Yeah, that's
I'll
why-
accept 250, that's why I had a question.
Oh,
I'll
you're right.
accept 250.
Good catch.
It's gonna be a good day though.
We'll eventually get these typos squared up. 1698.
Offer of cancel and bond, accept.
Accept.
99, I also have another email from Attorney Bernstein. A charge 2 alleges SLA investigator said it tasted like alcohol, and based on that, the charge was sustained. While the investigator's testimony was contradictory, and she could not identify the photograph of the so-called container that she took herself, we have not controverted this finding. The last charge was failure to conform with representations on the application. This related to a service bar that the licensee uses that was not shown on the plans filed with the original application. We have since started the process of an alteration application to add to the service bar. We appeared before CB4 on that last week. They have no objection, and it should be filed with us soon. In light of the foregoing, we request a $1,500 fine.
So their offer of 1,500?
Well, it's not really an offer. He's making a recommendation to penalty.
I have 3,000.
3,000.
And dismiss number one?
Yes, dismiss number one.
Got it. Okay. 1,700?
Offer of 2,500, accept.
Do we know there's food?
I didn't see the alteration application.
Oh, there was no kitchen, sorry.
You
Yes.
don't have to have a kitchen or a bar.
Other bar.
They've
just need a food
indicated, though,
truck.
that they filed alteration plan.
They have not with us, it hasn't reached us yet.
No, I haven't seen it.
But they do not, if it's a tavern, and I believe this is, they do not need a kitchen, they just need a food prep area.
There wasn't any of that.
Right, so they have to provide.
Well, it says they were priced.
What did their menu say they were gonna have?
They've already started construction of the, decreasing the size of the kitchen without submitting the alterations.
Yeah, we have no alterations, so they're in
they're-
violation again.
Cart before the horse.
We bring them in?
Worth bringing them in, or is it?
By then, they will.
Or send them a alteration application to be filed within so many days?
Yeah, do that.
Okay.
And I'll take the 2,500.
And do you want a warning, reminder about the food, or was this one? Food. Just the, I can send a warning on that, too. Got it. 1701.
Offer of 2,000, this is the issue where they have our RW, but they're selling wines to go.
Yes.
And I think we have to make sure we get everyone on notice that that is not permitted.
Explain this license to me. This is, he can sell wine in the deli and they can drink it there.
They can drink for on-premise consumption if they are ordering a meal
Okay.
and they have a bottle of wine and they don't finish the wine. The
Okay.
wine can be sealed up with the
Okay.
receipt
And our guy
stapled to
went in
it.
and bought one.
Yes, they can't sell it to
Unopened.
go
Okay.
unopened.
So what do you want to do, bring him in?
I think it's a more of a
Systemic.
systemic issue here.
Oh.
So I don't know how to best tackle this, just to nip it in the
Well,
bud.
in the past, I think the penalty has been between 2,000 and 2,500.
Okay.
It's been in the past.
Okay, all right. So I'll accept this offer, but I think if we start seeing this pattern, I think we really need to bring them in.
Okay. 1702. These cases are generally split between the EBT cards and the ATM, and the operation of the ATM.
Yeah, the last improper conduct is, what's the
It's-
last improper?
it's the same as
It's
the-
the ATM, right? So yeah, no, I'll accept the letter of warning.
I'll accept as well. So he's not notified. I'm assuming he's not notified about these after each one?
I'm not sure the process on that. They're not?
They're not, no.
And they seem to be very close together, so
Yeah.
I'll accept the letter of warning.
1703.
3,500.
3,500.
1704.
Okay, offer 4,500, I'll accept.
I accept.
1705 and 6.
Two people punched, they didn't call 911. I had counter 511 and
I'll agree with that. Counter 5.
1707.
let's see, they had arrested 3 times for gambling. Each time they were arrested.
And Mike, can you look this up?
And they
'Cause I
kept,
don't know, is this, what type of gambling are we talking about?
Well, what happened was Ms. Marsico could not get the police records and documentation, so she didn't really have the full details of what was involved.
So we don't have
So we
very
don't
good
have-
evidence,
Yeah,
basically.
we don't.
oh, we don't have very good evidence. Oh,
And we don't even know what happened with the arrest.
Correct.
Huh. All right. In this case, then, there's definitely a counter, 6,500?
I'll go with that.
$1,709.
Disorderly premises, they do have a long, good history. I'll take 2,500.
I'll agree with that.
1711.
Let's have 2,500.
2,500.
Dismiss number 2.
Yes, dismiss number 2.
1712.
Letter of warning offer, accept.
Accept.
1713.
3,500.
3,500.
1717. I have a request for the attorney. He's on vacation. Would like to carry it over to the next board meeting.
811 or
Wait, what number are you on?
18.
18?
1715. So it'll be the 818.
818, that's fine.
1716.
Revoke for the record.
Revoke, yep.
1717.
See, none within, yeah, cancel and bond. Did they ever pay?
No.
Okay, cancel and bond.
1717A.
I agree.
I agree.
Rule adopted.
Adopted.
1717B.
I was okay with the package removal. They've got an excellent history.
I'm okay with it too. The closest store's 12 miles away.
Got it. 1717H through N was adjourned to 818.
Which one, M?
That's the
One Oak.
One Oak, 17th Street, yep, okay. And I have no other items.
Wow, that's great.
Are we adjourned, Chairman?
Do we have anything?
Yes, we're adjourned.
Okay.